Milestones in real estate.
Key milestone A, engaging a vendor client. When the real estate agent meets the property owner who intends to sell their property with the help of the agent, the property owner is considered a prospective client. A prospective client, under Section 4.1 of the Real Estate Agency Act, is interpreted as a person who is considering or intending to enter into an agreement with an agent to carry out real estate work. Before any contractual documents are signed by the prospective client, under Section 9.7 of the REAA, a licensee must A. recommend that the person seek legal advice, and B. ensure that the person is aware that he or she can, and may need to, seek technical or other advice and information, and C. allow that person a reasonable opportunity to obtain the advice referred to in paragraphs A and B. A positive relationship where both parties communicate their desires is crucial in reaching the best possible outcome for both parties. Key milestone B, taking the vendor's property to the market. An honest relationship where both parties are transparent in sharing what they know of the property and its records is important in following the Real Estate Agency Act, avoiding any cases, and simply acting in good faith to all parties involved. The licensee must be reasonably competent in addressing no reports that come with the property. An example in how important this is can be found in Case 2, where real estate agent Leanne Robichowski failed to recognize the additional construction to the laundry contained in the LAM report supplied with the property. This meant that the property title was defective, and because Robichowski failed to recognize this, she's violating the REAA. Section 72 of the REAA finds a licensee guilty of unsatisfactory conduct if the licensee carries out real estate agency work that A. falls short of the standard that a reasonable member of the public is entitled to expect from a reasonably competent licensee.
Key milestone C. Once the property is taken to market, the next key milestone is receiving offers. In the property industry, it is not first in, first served. Offers from prospective buyers are sent to the real estate agent, who in turn passes them on to the vendor. A real estate agent has the responsibility to treat all potential purchasers fairly. The only real way to do this is to put the first offer on hold until other prospective buyers have put their offers in. This results in almost every offer being a multi-offer. If an offer has been received with no other potential buyers, an agent can put that offer on hold, but at the risk of the other offer being withdrawn. So in these cases, an agent may want to present the offer in a reasonable amount of time. Potential purchasers may instead send an offer to the vendor's lawyer, which would bypass the multi-offer process. Finally, though an offer has been received, it may not be to the vendor's liking. They have a right to reject the offer and make a counter-offer.
Key milestone D, enter into an agreement for sale and purchase with a selected purchaser. This is the stage once offers are made and received to the vendor. Within Real Estate Agency Act 2008, agents have a duty of care to uphold to potential purchasers. An example where an agent breached duty of care brings reference to Case Summary 1. James Warren Papuni, the defendant and real estate agent, was found guilty of misconduct under Section 73 of the Real Estate Agency Act 2008. Mr. Papuni and Mr. Zhao agreed upon facilitating the deal being split in two parts, the purchase of the Green Heights property and the $50,000 deposit towards the vendor's Royal Oak property. In doing this, the mortgagee of the Green Heights property was being deprived of the entire sale proceeds. Here we can see Mr. Papuni did not arrange a legal entry into an agreement for the sale and purchase of the Green Heights property.
Key milestone E. A deposit is essentially a good faith payment from the buyer that they intend to honour the agreement. Once both parties sign the agreement, the deposit is immediately payable. Strictly speaking, there is no requirement for a deposit to be any specific amount. However, the customary amount is around 10%. It is preferable for the deposit to be paid to the vendor's solicitor or agent rather than directly to the vendor to hold securely until settlement in a trust account. If a buyer doesn't pay the deposit immediately, the vendor can give 3 working days notice, or the vendor will cancel the agreement. When the purchase is complete, the deposit will become part of the purchase price. If the purchase falls through, then the deposit is forfeited to the vendor. A forfeited deposit was crucial in Case 1, where the vendor asked the purchaser to intentionally forfeit a deposit on a property which they had no intention of purchasing, as a way to bypass paying the mortgagee. Under the Real Estate Agency Act 2008, a real estate agent has the responsibility to act honourably and faithfully. Whilst forfeiting a deposit is lawful, using it in a way of misconduct such as Mr. Papanui is not.
Key milestone F, settlement of a sale of property. This is the final stage in which the ADLS is thoroughly agreed upon. During this stage, the purchaser can undertake due diligence. If something were to arise during due diligence, then the purchaser can legally extend the settlement until satisfied. An example brings reference to Case Summary 2, where an incorrect title was discovered. Mr. Roy Wojciechowski, the vendor, was found guilty of unsatisfactory conduct under Section 72 of the Real Estate Agency Act 2008, as well as Professional Conduct and Client Care 2012, Rule 10.7. Mr. Wojciechowski failed to pick up that the property title was defective due to a laundry addition constructed in 1991, recorded in a LIM report. A reasonably competent licensee would have addressed this and is obligated to inform the purchaser. After which due diligence and all aspects of the ADLS bar have been confirmed, then the transfer of title/ownership can occur.